Second video, we'll go through a few more issues and the Equal Pay Act as well, that discusses compensation and how it's paid differently to different kinds of employees. So let's talk first about living wages and prevailing wage laws. These are in separate sections of your book, but I'm going to put them together just to differentiate the two because I think some of you might get confused because they sound very similar, but they're actually two different things. The first one that the book talks about is living wages. So this is wages that some localities or organizations have promoted in order to raise the wage that the like entry-level employees or people who are getting paid minimum wage essentially would get. And the living wage is supposed to reflect the cost of living in the location that employees are in. For when localities do this, and when I mean localities, I mean local governments, so state or city governments, when they do this, sometimes it only applies to city or state employees or people who do business with the city or state. So it could be like contractors or subcontractors. It doesn't necessarily apply to all private employees, for example, in private organizations. Sometimes it only covers base wages, so it only says like what the minimum wage has to be, and it is different from whatever the federal minimum wage is or the state minimum wage. Although more frequently, they're starting to specify what benefits employees minimally need to have. So health insurance, a certain amount of vacation days, sick pay, some kind of job security, and incentives for unionizing. The incentives for unionizing maybe doesn't make sense unless you realize that a lot of places, localities especially, are passing living wage laws because they can see that a lot of organizations are only paying minimum wage to employees and it's not enough to cover the cost of living for that location. And a lot of times employees are only getting the minimum wage because they're working in industries or in organizations that are not unionized. Because most of the unions that we have now are not in private organizations. They're often in state and city governments or in the federal government. So if you have city or state employees who are not part of a union, but aren't getting paid very well, if you put in incentives to unionize in your living wage laws, it's much more likely that you'll actually be able to get the kinds of pay that you want and that either workers will be able to unionize or will at least be able to keep their wages up with the cost of living if you kind of, I don't want to say threaten, but if you give them some incentive to unionize in the future if their employers are not treating them well or not paying them very fairly, or at least the cost of living. These living wage laws are different from prevailing wage laws. Prevailing wage laws are from the federal government, and what they do is they set pay for work done by those who are contracted or subcontracted by the federal government. A very common way that this happens is in construction work. So these prevailing wage laws are often much, much higher than the wages, like the minimum wage, and even potentially the wage in the area or the locality where that work is being done. That means it can sometimes skew the economy, or at least the wages for other workers in that industry that are not working on those federal contracts within that area. But this is also to account for the fact that when you have contractors who are doing things like big construction projects, they're bringing in employees that are not from that area, and those people have to pay for their transportation. They're having to live in temporary housing. So there's lots of other expenses that may be involved in some of these very large federal projects. And so the prevailing wage laws make sure that employees are getting paid fairly for what they're having to sacrifice to do that work. Another very recent issue that we've had, I would say the last 10, 15 years, is whether people who are working for organizations are considered employees or independent contractors. And I think this has become a much bigger deal with organizations like Uber, where essentially almost all of their workers are independent contractors, except some of their employees that are working in corporate offices. So one thing we haven't gotten to in the book, but we'll be talking about later in the semester, is that employers are required for their employees to pay Social Security taxes, unemployment compensation, and workers' compensation taxes. And if you've ever had a job in an organization that paid these for you, you'll see them on your pay slip. It will say, it'll show you how much you paid for those taxes, how much your employer paid, and how much you paid for those taxes on your pay stub. An independent contractor that has to pay those for themselves. So the employer doesn't take out those taxes or doesn't pay them for that independent contractor. And in fact, an independent contractor is responsible for paying their own income tax too. So their income tax is not withheld by their employer. They have to pay it usually quarterly to the federal or state government that they owe that money to, because no one's keeping that money out of their paychecks as they're working. To determine if a worker is an employee or an independent contractor, the courts and even the law have tried to designate some ways that we can look at this. So one is behavioral control. How much control does a worker have over the tasks that they do? If you're an independent contractor, you get to choose the kind of work you do, and then you sign a contract to do the work that you want to do. If you're an employee, you may not have as much choice. Your supervisor may tell you what you're going to do, and you have to do it if you want to keep your job. Financial control is another way that we can look at this. So how much is a worker investing and how much is the business paying the worker? So if you're an independent contractor, you're investing for pretty much everything. You have to buy your own equipment. You likely do not have an office in the organization to work. You have to pay for your own training and development. And then the business is paying you some lump sum for either a project or for the amount of time that you're going to work on that project. But you may not be paid like on an hourly basis, for example, or you may not be getting a salary every 2 weeks because you're not an employee that's getting paid like other employees. And then finally, the type of relationship in that contract can also determine whether someone's an employee or an independent contractor. So if the employee is being given benefits, or if the worker is being given benefits, they're more likely to be an employee than an independent contractor. If they have a permanent relationship, or that would be an employee, but an independent contractor is likely to have some kind of time limit on their contract, or they're only being paid for a certain project, for example. And when that project ends, they're no longer working with that organization. And then whether the worker does a key aspect of regular business. So are they doing a lot of the main business that that organization is involved in? So for example, if you have employees, if you make cars, for example, and you are hiring independent contractors to do things in the manufacturing process, like put a door on a car or put in lights in the front or something like that, you could go to court and say, I'm actually an employee, not an independent contractor, because the work I do is the main work that this company does, which is make cars. Pay discrimination is another issue that we have to talk about. We'll talk about this in the third video as well. There are two kinds of pay discrimination that our book talks about: access discrimination and valuation discrimination. Access discrimination is about access to things that you would normally get at work. So whether you have access to jobs, are you getting hired? Are you even eligible for jobs that you're actually have met the qualifications for? Do you have access to promotions? Do you have access to training and development? In the past, remember, a lot of these laws are created because there's past discrimination. Women and people of color were not allowed to get certain kinds of jobs. They were not allowed to get promoted into leadership. They didn't get the same training and development as other employees. This still shows up in a lot of different ways in the ways that we work. So you can see segregation by job. So who works the kinds of jobs that are in leadership versus entry-level work, for example, in an organization. Occupations, who works in caring professions versus who works in professions that deal with money and technology. Industries, are you working competitive industries, or do you have industries that are not as competitive where employees may not be making as much in wages? And then what kind of firms? Some firms are more likely to hire women and people of color than others. Valuation discrimination is more important maybe for compensation because it's literally about how people are being paid. Are they receiving equal pay for equal work, essentially? So in the past, women and people of color were not paid the same, even though they were doing exactly the same work as men and white people, because they were women or people of color. And so that's where in the next slide, we'll talk about the Equal Pay Act, where we started trying to rectify these situations by passing laws that said you can't pay people differently on non-job related for non-job related reasons. So the Equal Pay Act of 1963 was one of the first laws that starts talking about equal pay for women here especially, but for any kind of protected class or protected group within all of the anti-discrimination laws that we have. So the Equal Pay Act prohibits wage discrimination on the basis of gender if employees perform equal work in the same company. Equal work here means that the work isn't exactly the same job title or even the same exact tasks, but that these jobs require equal skills, equal efforts, and equal responsibility or accountability, and they're performed under similar working conditions. So both of these jobs work in the office, for example, or they don't work in hazardous working conditions or something like that. If you have any of these differences at all in skill, effort, responsibility, or working conditions, that might be the basis for why some people are getting paid more than others in these otherwise equal positions. So there are 4 criteria we can use to determine when it's legally okay to make differences in pay because of these are job related reasons for paying some people more than others. These would be considered an affirmative defense if you use them in court to defend your compensation system, the decisions you made around it, and why some people make more than others. So the first one is seniority. If you have people who've been in their jobs or in the organizations much longer, or who are higher up in the hierarchy, then you can pay them more than people who are lower down or have less time in that job or in that organization. And the idea here is the longer you're in an organization or job, or the higher up you've gone in the organization, then that means that you have more experience. So you can use that in your job for better results. The second one is merit or quality of performance. So how well are people doing? If you have an employee who's doing a stellar job versus one who's just doing a good job, you might pay more for the stellar performance because your incentive system might be based on merit or performance. The third one is quality or quantity of production. So if you have some employees who are just more efficient and more productive, they're making more money for your organization, so you can pay them more because they're much more productive. If you have employees who have high quality work where clients and customers are impressed and are willing to pay more, then that definitely is making you more money as well, and so you can pay more for those employees. And there might be some other factor other than sex that might be involved, and that's in the next slide, what kinds of factors those could be. One thing you have to consider when you're looking at whether people are doing equal pay for equal work, the equal work is not on their job description, because a lot of us do things that are outside of our job description. It's based on the actual work they perform. So what are they really doing from day to day in their job? That's how we determine if someone's work is equal to someone else's. So what are some other factors other than sex that we can consider in paying people different amounts? One is shift differentials. We may have shifts like night shifts where people don't like working them. So we're willing to pay a little bit more for people who are willing to work those shifts. We can have people who are doing temporary assignments where they're taking on more work because there's a position that's unfilled that the work needs to be done. Maybe someone's on parental leave, someone's been injured at work and isn't working for a few weeks. If someone's taking on that extra work, they should get paid more. People who are part of bona fide training programs where they're getting like a certification, for example, or something that's officially saying they've learned some new skills that they can use in their job, that can also be the basis for paying them more because they've now invested more time and energy into their job than someone who hasn't done that kind of training. You can have also differences based on ability, training, or experience. Again, you can have employees who have skills that others don't, or have abilities that others don't, and you might be paying them for that, even if they're not using it in their job right now, because it makes them more flexible, and you can help switch them around to other jobs as you might need them. And then you can have other reasons that are related to business necessity, but you would have to describe very well in court what that business necessity is. It could be something like, in the last few years, a lot of organizations haven't been able to find enough employees. So you could say a business necessity was to pay your new employees a lot more than you used to pay them a year or two ago because there just aren't as many, but you absolutely need them to do the work in your organization. And that might be considered a business necessity. One concern we have with the Equal Pay Act and the way that it can sometimes be implemented in an organization is that we can have reverse discrimination, where there's so much thought and so much concern about how women and people of color are being paid that sometimes men, and particularly white men, aren't getting the same opportunities and for increases in pay, or even aren't getting the same base pay amount as women and people of color are getting. So one thing I want you to remember is one of the objectives of our system isn't just to comply with laws and regulations, but it's to create a fair pay system or compensation system. And that means fair for everyone, not just fair for people who have historically dealt with discrimination in terms of pay. So that means we need to be keeping data for everyone and then using that data to figure out okay, when are certain groups getting paid less than others? Is reverse discrimination happening? Are women still getting paid less than men? Are people of color getting paid less than white people? We want to look at all of the groups because there could be an issue for all of the groups, not just the groups that have historically been discriminated against.